proper commandeering of the states?
Well, let me say I agree with everything Professor Barnett said. The question that Tom, you asked is what would happen if the individual mandate was struck down? And I answered that. But, you know, I think that there's a very essential distinction in terms of where the money goes, and following the money is a lot of what commerce is all about. Social Security is a mandatory insurance program. It is funded by a tax that goes into the United States Treasury, and the benefits for Social Security and Medicare A come out of the United States Treasury either as payments to eligible recipients or payments to hospitals. What goes on here is that there is a mandatory payment to a private corporation, which are these exchanges that are set up pursuant to the Obamacare law. And there is a big difference between a tax that goes into the United States Treasury and benefits that are dispersed from the United States Treasury to people who are eligible, and a payment that goes to a private corporation, which in turn makes the disbursements out of the private corporation treasury to people who are eligible. And that's a pretty big distinction that the court's going to have to wrestle with.
Well, was the answer from the left, let's nationalize the private insurance companies and make it a mandate that you buy government insurance since there's no other type?
Well, that's the single payer system that they have in Canada, and in a somewhat different form in the United Kingdom. And, you know, the Canadian government is limited to a certain percentage of GDP how much they're going to pay on health care, and that system would have completely fallen apart had not 90% of the population of Canada living within a 2-hour drive of the border. There are a lot of Canadians that have to come to the U.S. for their health care simply because the waiting lists are far too long in their own country to get it.
Well, I do think that there would actually, unfortunately, and this is because of what the Supreme Court's done through the since the New Deal, there would be fewer constitutional objections to such a program than there is to the individual mandate. So it's sort of ironic, and people who defend this bill say, well, that should mean something. But actually, I think it just means that if that the courts have given Congress too much power under their interpretation of the Constitution, and that's not going to change anytime soon. In fact, many conservatives on the court go along with this quite readily as well. It's not just something confined to the liberal side of the court. But there's no political will for that kind of thing. So here is where the political process would stop that sort of thing from happening.
What about, now to date I'm only aware of state government challenges to Obamacare. Let's say there was a public interest group like Judicial Watch interested in a constitutional challenge, or even an individual citizen. Do either of you have any ideas as to how such a challenge might be constructed and proceed, or when it would be ripe?
Well, there already are individual challenges that have been filed. So if you need to have one, if for any reason the state attorney generals don't have standing to assert the rights of their citizens with respect to the mandate, there will be individual lawsuits that will provide that standing. Maybe this is a good opportunity to talk a little bit about the other constitutional challenge that the states are bringing, which I think actually has a considerable amount of merit. They're objecting to the mandate, and Congressman mentioned this earlier, they're objecting, this is actually a separate constitutional challenge, objecting to the mandates placed upon them to set up these insurance exchanges. And if they don't set up these insurance exchanges, then they're going to be forced to greatly increase the cost of coverage under Medicaid under their states, and if they don't, to amount in excess of what they have to do today and in excess of what states do who set up the insurance exchanges. And if they don't want to do that, they have to drop out of the Medicaid program and forego all their Medicaid reimbursement from the federal government. So they're challenging that on the basis of the fact that that is an unconstitutional commandeering of the state. And I already told you the Supreme Court has prohibited as improper prohibitions, commandeering of state legislatures, requiring them to pass laws, which in fact is what this measure seems to require. Now, the defense of this measure, and it's a pretty well recognized defense or theory, and that is that Congress is free when it's spending its money to place conditions on the expenditure of this money. So when Congress decides to spend money on Medicaid, it is free to condition its Medicaid expenditures on requiring the states to do anything that's really related to, in this case, what the expenditure's for, which is for medical insurance or medical coverage. And this setting up the insurance exchange would be considered to be related to the expenditure and therefore constitutional. Let me just stop for a minute and say this again. It means that because Congress is just placing a condition on its money, it's not directly commandeering the state. It's simply saying, if you want to take federal money, then you have to do it this way, and that's something that's done all the time. That is the other great power that Congress exercises all the time. It's how, for example, the speed limits got made that nice, friendly 55 miles an hour over state objections because highway funds were conditioned on them doing that, and how the drinking age got raised to 21 throughout the country because highway funds were conditioned on states passing those laws. Okay, so that's a well-established route for exercising constitutional congressional power. What's wrong with it? What's wrong with it is that when the Supreme Court upheld, for example, the mandate that states raise the drinking age to 21, to the age of 21, or lose their federal highway funds, what the Supreme Court said is that this is not coercion on the states because only 5% of the highway funds were made conditioned on their raising the drinking age to 21. And because it's only 5% of the highway fund, construction funds, therefore this is not coercive. Well, this is an entirely different matter, what we're facing here. We're talking about the forfeiture of 100% of Medicaid funds, which is probably compensating states for their largest appropriation, a huge amount of state budget. If that's not coercive, it's not clear that anything would be coercive. And so the South Dakota versus Dole case, which upheld the condition placed on highway funding, in the condition that everybody raised up the drinking age to 21. South Dakota versus Dole does not automatically sanction this kind of a condition placed on 100% of Medicaid funding. That would definitely be coercive. And if it's coercive, then it is the mechanism by which the states are being commandeered, and commandeering is improper as an interference with the authority of states. This is a very serious challenge, and that's something that really only states can bring, and they would definitely have standing to bring that.
Let me say, I think the question involves whether a court would say a plaintiff has standing. I believe that it is clearer as a result of the Massachusetts versus EPA case that states have standing than it is whether an individual plaintiff who claimed that he or she was financially or economically hurt as a result of the individual mandate would have standing. The Supreme Court, when it's wanted to dodge particularly controversial issues, have always hung their robes on the standing question. It has been, I think, more and more apparent that the court has given states standing as a result of federalism, beginning with the case in 1992 when the federal government tried to give title to nuclear waste to the states, and New York challenged that and won. So, as a result, no state ends up having title to nuclear waste. So, there was a case where the state very clearly did have standing, and I think the combination of these two cases indicates that the states would have a better shot of winning a constitutional challenge over standing than individuals would.
I have more questions, but I'm going to open it up to the floor, share the wealth. I think we have a microphone, so if you could wait for the microphone and then identify yourself and direct your question or brief comment. We don't have time for lengthy back and forth, so if you could keep anything you have to say succinct, I'd appreciate it.